Hi, I'm Lara Halperin, and I'm the co-director of the Queer Portfolio of the Melbourne University Law Student Society. Today, I have the fantastic opportunity of interviewing the Honourable Michael Kirby on the topic of advice for the next generation. Michael Kirby, thank you for being with me here today.
It's my pleasure. I always love coming to Melbourne University Law School. It's a great law school with a big queer community.
Absolutely. Did you actually notice the painted stairs, the rainbow painted stairs in the law school?
I didn't see that, but I did see a rainbow flag that I signed on the occasion of the acceptance by the Australian people and Parliament of marriage equality.
Fantastic.
So I had to put another message, and the message was progress made, more to come.
That's really inspirational. That's beautiful. From your experience as a student, a lawyer, a reformer, a public figure, and former judge of the High Court of Australia, what advice would you give to the next generation of future lawyers?
Well, I think a very important thing to do is to be a joiner. That means not to just live in your own little world and concentrate only on your own personal success, but take part in society. And that's not just an LGBT society, it's the broader community. And that's what I did when I was young. I got involved in the Council for Civil Liberties, student politics, and other activities, and that gave me an insight into the law which wasn't necessarily as self-congratulatory as a lot of the things I heard at law dinners and functions in the profession. So I think doing work for others, and especially others with legal problems, doing work pro bono. You can't do everything pro bono, but mixing and matching your professional life with help to others. Law is or should be a helping profession, and it is or should be concerned with justice. We are not just mechanics doing mechanical tasks. We are involved in developing and expounding the law in such a way as to make sure, as far as it can be done, that justice is achieved. Equal justice for all.
It's beautiful. Thank you. So my second question for you is, what are the biggest challenges that you think people of my generation and future lawyers will face, and what advice do you have from your time in office on how we can confront and deal with those challenges?
Well, first of all, it depends on whether you're thinking about challenges in the world, and there you would have to be thinking of the great challenges of controlling nuclear weapons, of responding to pandemics, of responding to climate change, mass migration, and all the other problems of our world today. But if you're thinking of challenges that arise in the legal life, in professional life, they certainly include the overriding challenge in common law countries of access to justice. We are a Rolls-Royce system. We are a very expensive profession, and that's not going to change anytime soon. But we have to make sure that within our paid work, we do work pro bono and for people who can't afford the law. And we also have to try to ensure that with the advent of artificial intelligence, that we use this remarkable new development of technology, which is on the brink of impacting the law, to try to overcome the difficulty of access to justice. How do we make, for ordinary folks, the statement of the law and the legal decision in cases more readily available? And I have a feeling that artificial intelligence properly controlled so that it still has the human element of the quest for justice will be a way by which, at least in simple and routine problems, ordinary citizens can have a much cheaper access to the law than is the case at the moment. If you look at all those big firms up there near the sky with magnificent artworks and beautiful offices, in Sydney harbour views, in Melbourne river views. You have to acknowledge that somebody pays for all this, and it's a very expensive business, and that's why we've somehow got to solve the fundamental problem of the common law system, the adversary system, of delivering the legal product in a way that is more affordable to ordinary citizens.
Oh, that's really interesting. I'd love to know what you think about ChatGPT and how that's going to sort of play a role in the legal profession as well.
Well, when I started out in the law, it was very difficult to find what the law was on a particular matter. And in particular, it was very difficult to get the up-to-date provisions of a statute. I mean, it seems remarkable that that should be so, but 3 lawyers in Australia, Graham Greenleaf, Philip Chung and Andrew Mowbray, developed and commenced the Austlii system. And that has been copied in India, in Britain, in Ireland, in Canada, and all around the world, that gives people immediate, accurate, up-to-date access to the state of the law. But that's only the first step in the quandary. The second step will be to give access to a solution to a legal problem. And that is something which I think artificial intelligence and the various forms of it that are being developed now will make possible. An ordinary citizen in their home should be able to feed in from their perspective the point that they wish to have resolved authoritatively and get an answer. That isn't so at the moment. They've got to go through the business of going to lawyers and speaking to them and getting contrary opinions and different opinions, having cases, expensive litigation, and that is inherently a Rolls-Royce system of justice. And not many people can afford a Rolls-Royce. So that's our challenge. And I hope that artificial intelligence and its variants will not be a big threat to our liberties, nor a big threat to the humanity of law and human decision-making and the search for justice and the desire for justice, which is a very important aspect of the legal profession. But we will have this made available to people, at least in the preliminaries, so that they can get artificial intelligence to deliver the goods on what is probably or possibly going to be the solution to their problem. And that may cut out a lot of cases that otherwise would amble along in the legal system, slowly, methodically, justly, but very expensively. That is a major feature of the law, and it's actually become worse in my lifetime than it was when I was a young lawyer.
Interesting. How has it become worse?
It's become worse because when I started out, the law had some funny arrangements. One of them was the monopoly given to lawyers in land title conveyancing. And that meant lawyers could do work which fundamentally was very routine, but they could then have money from that work to cross-subsidise other work. There were cases of people with criminal law problems or compensation problems, and that was what was done in those days. But that isn't possible now because a lot of those monopolies have been lost. Other areas of the law have been simplified, and the net result is that many people, when they have a real problem, find it very difficult to get a lawyer whom they can afford. And so that's only one issue, but it's certainly an important issue in the law as I see it today.
How do you think that the next generation of lawyers can deal with the challenges of AI?
Well, they'll deal with them as my generation deal with their challenge, and previous generations dealt with their challenges. The lawyers of today are much more tech savvy, and they're much more capable with technology to get the data that will inform their minds and allow provision for advice at a cheaper rate. And I think that's an important aspect for hope. You're not going to be able to ban artificial intelligence. This is a mighty new development. It's like the advent of computers. It's like earlier the advent of photocopiers. And new technology will bring new problems, particularly ensuring the human element, the will to do justice that led to the Mabo decision, for example. But if it's purely mechanical, then that will merely instill the repetition of injustice that existed before. You need something to break the cycle. Charles Darwin, in Origin of Species, said the most important chapter in his book was the rule of variation. And the rule of variation is thinking freshly about the law and being strong enough to insist that others think freshly about it too. That's what, in my way, I've tried to do, and many others as well, and it's what you should try to do in your lifetime.
So you became known as the Great Dissenter, largely due to your attention to international law and human rights as foundations for the Australian common law. What advice do you have for the next generation on how they, like you, can stand for what is morally and ethically right in the face of the majority's view?
When I was a practicing lawyer and when I was a judge, I didn't deceive myself that I could just go and sit under a palm tree and give decisions or advise clients on what the law should be, in my opinion. You have to be anchored in the text of the law. And I gave a great lecture at Melbourne Law School on interpretation of law, text, context and purpose. And that's in the Melbourne Law Review, and it's still a good basis for approaching, finding and applying the law. But that means my advice must be to those who are coming along to make sure that they don't just get locked into text, because that will mislead them into expressing and developing the law in a way that is in harmony with the times we live in. Context now includes international law, and context includes the law of human rights and the general expectation that the law will reflect basic rights. Therefore it's important that lawyers today should take these lessons, learn them at law school and then apply them in their lives as practitioners of law, and if it comes about as judges of our system, bringing law according to justice and justice according to law. And I'd never found it difficult to stand up for what I believed in. Of course, I was a judge, and that was what I was required to do. But all lawyers have their independence and their integrity, and where things do not seem right, they should struggle, as Lord Denning said, searching the precedents high and low, and searching now the internet and AI to find solutions that bring justice to ordinary citizens.
What's your advice to the next generation on how they can stand by their ethical and moral values in the profession?
Well, you have to think of the environment in which a problem arises, and you can't just go around talking about morality. The law is not undiluted morality. You have to bring things into line with the statement of the law and the principles of the Constitution and of statute law and of common law. And I never advocated that you should just do what you think is right. And I never did that on the High Court of Australia. You've got to be anchored in the law and especially the text of the law. But within that, as my great law professor, Professor Julius Stone at the Sydney Law School taught us, judges and lawyers have leeways for choice. Melbourne Law School is very famous for its teachers of jurisprudence. It has been all my lifetime, and leeways for choice mean that lawyers have a responsibility to consider the justice of a problem and the justice of the solution. And that is not alien to the law, it is essential to the form of law that we have, and lawyers must speak up for justice according to law.
Do you think that being queer affected your approach to statements of the law?
Well, of course, for most of my life, I was pretending to be a very straight sort of a man, but I always knew that there were aspects of our legal system that were, frankly, just unjust. But not just for queer people, they were unjust for Aboriginal and First Nations people, unjust for people who were not Caucasian, unjust for women, unjust for migrants, and unjust for other groups in the community who were minorities. And therefore, I suppose that my sexuality did affect my sensitivity. I had antennae, and I would know if something was discriminatory and unfair to a minority, and I didn't like it. I didn't like it for myself as a queer man, but I also didn't like it for any of the other groups. And we in Australia still have problems with minorities, and as lawyers and as citizens, we have to overcome those problems and stand for a better Australia that brings equal justice under law to everyone.
Your very last decision on the High Court was Wurrajul and the Commonwealth. Do you think that this presents something abiding about your position on the High Court?
Well, I hope so. It was a case concerning the challenge to the Northern Territory intervention that had been enacted by federal parliament. And under the intervention legislation, they were permitted to seize Indigenous people's property, and they provided in the legislation to give just compensation. That was the phrase that existed in the American Constitution, but our founders chose a different phrase deliberately. They said just terms. And the one thing they didn't do in the Wurrajul case and in the Northern Territory intervention was to consult the Indigenous people. And the Indigenous people came to court, and the advocacy was by the Solicitor General of Victoria, a wonderful advocate and a graduate in New Zealand in law, who presented the proposition that just terms included proper consultation. Nothing about us without us. And so her contention was, in the Northern Territory, we've had altogether too much decision-making by whiteys about the First Nations people without consultation. Nothing about us without us. So I simply said, the difference in the Constitution is just terms, and not consulting the Indigenous people is not just terms. They get the money, but they don't get the consultation before radical provisions are brought in, and that is unconstitutional. And I still think that that was a correct application of the Constitution, but I was the only justice who took that view, so that was a case of being the great dissenter.
Thank you so much, Honourable Michael Kirby, for the advice that you would give to me and other future lawyers of the next generation.